a year after the government withdrew Personal Data Protection Bill, it's all set to table the Digital Personal Data Protection Bill. The bill governs digital personal data by providing a legislative framework. It highlights the rights and duties of citizens and the obligation of businesses dealing in data. The bill is also worrying on various parameters, including that the bill provides exemptions for government agencies, which raise concerns about possible misuse of personal data by public authorities. While the bill calls for setting up a data protection board, critics argue that Digital Personal Data Bill or DPDP could also allow government to direct any entity, government entity, to furnish information as it may call for, allowing central government more control over public data, data that is our data, people's data. We're going to discuss the implication of data protection bill. It's going to be tabled in Lok Sabha very, very soon. Joining us at this point in time is Kanish Gaur, who's the CEO of India Future Foundation. With me is joining us Kartik Malhotra, Amit Ranjan. Gentlemen, both of you, please do come walk in and explain to us, Kartik, what does this bill mean?
So I think, Shweta, the bill has been tabled in Parliament right now, and we should be getting input of the Minister Ashwini Vaishnaw and some input from Parliament right now as the bill gets tabled. I believe it has been tabled right now as you're speaking, and in some time we should be able to get visuals. Until then, let me just try and explain to you and our viewers what this data protection bill or the Digital Personal Data Protection Bill 2023 really means. Now, let's look at the critical players here. There are three players in this whole equation. One, of course, are the data principals. Who are the data principals? Data principals are you, Amit, me, the citizens of India, also called the digital Nagriks. These are people who have a digital footprint, who offer or consume data and leave some sort of a digital footprint by way of personal information on the internet. Where is this information captured? That's the second player, data fiduciaries. Who are these data fiduciaries? Data fiduciaries are companies, businesses, startups, etc., who use this data. They use this data because this is the data that we have provided them. We have put our phone number, our email ID, our Aadhaar number, our PAN card details, etc. Anytime you book an airline, anytime you do an online shopping, anytime you check into a hotel, there is data that is getting exchanged. This data is held by data fiduciaries. When you offer your Aadhaar number or your PAN card or your phone number or your email ID, anytime you've gone out shopping, that data gets captured somewhere. That data is captured with the data fiduciary. The third player here is the Data Protection Board. Now, the bill adds Data Protection Board as a third critical player in this overall scheme of things, and this is a government appointed body which is going to ensure that the data that we offer to our fiduciaries and the fiduciaries who own this data, that data stays protected. Okay. Now, let's look at the fine print very, very quickly because the fine print is actually important. Now, what this new data protection bill suggests is that data collected by any of these fiduciaries can't be shared with another company or with somebody who wants to acquire this data without a formal consent of the data principal. That means a frictionless consent form very clearly articulating what our data is going to be used for, where it gets transferred, to whom it gets transferred, in which context. That becomes a very critical measure where these data fiduciaries cannot share data with any other organization without a formal consent. There's one more point to it. The other point is that the frictionless data also has to work in the reverse. So if we can move on to the next graphic, it shows that, we are...
Before we move to the next graphic, because those are important fine prints, we have a quick bite of Ashwini Vaishnaw while he tabled that bill in Parliament. Let's quickly cut to that first.
Honorable Chairman Sir, I rise to move for leave to introduce a bill to provide for the processing of digital personal data in a manner that recognizes both the right of individuals to protect their personal data and the need to process such personal data for lawful purposes and for matters connected therewith or incidental thereto.
IT Minister Ashwini Vaishnaw tabling that very, very important bill. Before we go to concerns, I've been building concerns. Let's also, quickly understand the fine prints. You were, of course, Karthik, taking us
so
through
that's what
the
Ashwini
fine
Vaishnav
prints.
also just said, the Honorable Minister for IT. And now the point is that, once we are talking about frictionless sharing of data and the consent form to be very, very frictionless and easy and clearly articulated, even the reverse of that has to be as easy, which means I should be able to, as a data principal, withdraw my consent. As soon as I find out that I don't want to continue sharing my data, I should be as easily able to withdraw it as easily as I comply with sharing of it. And any breach of data by a fiduciary has to be reported to the data principals, which is us, and to the protection board. Okay. We'll come to the concerns subsequently.
All right. Let me also quickly get in Amit into this conversation. Amit, you've been tracking this story. We don't have our guest through just as yet. I want to understand from you what's happening here. Government says the intent is to protect citizens, us, the digital Nagriks, because we've been raising concerns around data being breached, data being shared without consent, and this bill will provide a framework where you and I will be able to consent to where our data is used. So where's the problem?
There is some fine print where the problem is. One is what has surprised experts is the takedown clause, that the government can now does not need to request a platform owner to take down certain content. It can just take it down or block it altogether as advised after the advice of the Data Protection Board. So Data Protection Board is going to advise the government on content and on grievances of individual data owners who are the data principals in this matter. The other fine print regarding the fiduciaries and the principals is that if a principal has put data with a fiduciary and has not specified or restricted them to process it, the fiduciary is free to process that data. Processing does not mean giving it out to another third party, but processing it for its own, the way it uses that content. So that is a little bit of a fine print. The upside is that there is a telecom dispute settlement and appellate tribunal which has the power of the civil court, where grievances against the advisors of the data protection bill can be challenged.
All right.
So anybody who does not like the decisions of the data protection bill, there is a body which has the powers of a civil court where these grievances can be taken on and challenged.
All right, but this body again is a government body, essentially.
So two bodies here, from what I understand from what Amit is saying. One, of course, is the Data Protection Board, and the other is the tribunal. And the tribunal, I think, is for grievances. So the Data Protection Board's job is to ensure, it's like a regulator, or it's like an association, like let's say the DGCA or the TRAI. These are government appointed bodies whose sole purpose of existence is to ensure that compliances are met with. Now, in case of a breach of compliance, the authority lies with the Data Protection Board to either impose a penalty, which I believe is now about 250 crore rupees, except that there is no criminal proceeding likely to happen against a fiduciary who happens to breach the data compliance, right? But coming back to the point, so now in case of a conflict, in case of any sort of a dispute between the fiduciary and the data principal, or the data principal, data fiduciary and the Data Protection Board, in case of any sort of discord between them, the tribunal comes in, which has the powers of a court,
of a civil
court, to be able to decide on matters in favor of either party.
All right. Kanishk is joining us at this point in time. Kanishk, good afternoon. We're discussing, of course, the fine prints of the Data Protection Bill. It's now tabled in Lok Sabha. It's going to go through as a regular bill, not as a money bill, which essentially means it will be discussed in Lok Sabha, will then subsequently go to Rajya Sabha. Concerns were raised by opposition parties, concerns were raised and concerns continue to be raised by people who track, monitor data privacy laws. What is the concern here with this bill?
The concern is that takedowns will going to take place in the name of national interest, which might violate freedom of expression for certain individuals or people who are involved in activities which are from civil society. Second, in terms of platforms being pushed to take down certain content, which the government believes can cause larger harm, can be tracked, put as information warfare, misuse. So it gives government additional authority to take down. They will no longer be going after the platform saying take this content down. They would have authorities equivalent to judiciaries to do this much more stronger. So that's one of the key concerns. Right. The other thing is there,
All
the
right,
right to be
before we go to your next concern, I think what my colleague Karthik here was alluding to is that even if the board does take a decision, there is going to be an authority where you can go and challenge that decision. Essentially, a semi-court-like authority, a tribunal, where you can challenge that decision. So the tribunal may be able to reverse the order of the board. Does that not give some sort of leeway to people where they can challenge a decision made by the government?
So it creates a quasi-judiciary authority. Right now, this kind of work is being done by the courts. So if you look at the case which is happening in case of Twitter and the Ministry of Electronic Information Technology, Twitter went to the Karnataka High Court against specific blocking orders. Now, this mechanism creates a quasi-judicial authority. So there are issues in terms of maker and checker. If this entire body is under the Ministry of Electronics Information Technology, then there would be people who would be crying out, okay, that we will no longer be able to put this in front of the court, or it will tomorrow create conflict uh, on this particular matter. So the whole aspects on keeping this authority independent are questions of grave concern right now. That would this be completely under Ministry of Electronics Information Technology, or would this be an independent body? Who are going to be the people who are going to be part of this? How independent they will be? What would be the job description according to which they would be chosen? Right? Will there be people who have served as honorable judges of different
Right.
high courts or Supreme Court? Those are larger concerns. What would be the formation? What would be their knowledge? Right? How will they exercise powers? What will be the provisions and the penalty? The biggest part. So this bill talks about penalty up to 250 crores, right? From 10,000 rupees to 250 crores. So this increases the liability, the cost for platforms and businesses to do work in India, right? And certain aspects around
But
keeping data in India will obviously,
cost only in case there is a breach and a breach established.
yes, breach established. So the thing is, one, if a breach is established, they will put out penalties. But also in terms of storing that data, because there are aspects in terms of what data needs to be kept in India, what data needs to be shared. For getting this data to be shared, you will have to create those local copies or access, giving access. Now, if you've got cloud services set up, localization, that is going to be additional cost, particularly for the tech platforms. And we have so many tech platforms which are operating in India. We have only focused on maybe three or four the big tech. So the larger tech platforms will come into the picture. The intermediaries, that's going to be there. Then consent mechanisms, that's significant cost. How do you build out consent mechanisms from every user for letting them know how your data is getting accessed, shared? What kind of tools and technology are you using for monitoring them? So if you're allowing people to access a particular website and you want cookies to be accepted, right now nobody really checks, everybody just accepts. So you have to define what kind of monitoring you're doing, tools, mechanisms you're doing to
Right.
monitor their data, monitor their devices. All of this will require significant amount of investments from companies to make. Even the consent mechanisms in terms of getting people to sign up on mobile apps or web apps or even a POS,
Right.
that storing it, sharing it, even the third-party suppliers. There's a lot of companies which have more than 50,000 third-party suppliers which are operating, large telecom service providers. All of that data goes outside. So keeping them under check, building a data governance mechanisms, safeguarding your business from third parties is going to be very, very important. Because you
Okay.
might be running a large retail business, but your data would be completely be managed by a large IT service provider. And because of that large IT service provider, you could be under a liability or a breach which could go up to a large number. I won't say 250 crores, but even 50 crores. Then what is the skin in the game for this large IT tech company? So that's those are going to be some of the key things. So the contracts in India will have to be redrawn today to look at the service providers are also taken into account. The aspects with respect to children, how do you draw out children to give consent? You'll have to have parents involved. You'll have to have, uh, you know, consents being taken, who is authorized. All that plays a very, very important role.
All right.
Aspects such as encrypting, masking data. So when you're sharing this data with a third-party service provider, what kind of data access you are given. So that's large amount of work. So the implementation would incur significant cost, not just for the tech companies, but also for the companies which are providing the hardware.
All right, those concerns are fair enough. There are concerns with respect to consent. How do you, Karthik, acquire consent? What about kids who are less than 18 years of age? That's number one. Number two, data localization, the cost of data localization, that is another concern. Number three is compliance. How about data that is shared outside of this country? Every time you can't go to the government of India to take consent. All of those, of course, are going to be challenges that the bill will either have to mitigate or answer. We don't have the fine prints of the bill just as yet, but what Kanishk is alluding to is that costs for small companies becomes a lot more higher because the contracts will have to be now redrawn.
So, Shweta, I think, see, the concept of utopia doesn't exist. There is no perfect world. Life is full of challenges, right? But I'm not talking, philosophically, I'm talking pure business. Every business and every compliance and every rule change comes with its own set of challenges. But compare this with no policy in place at all. Any retail outlet you walk into, you share your phone number, you share your email address, you swipe your credit card, there is a digital footprint you are leaving. And right now, with in the absence of a consent, God alone knows where all that data is going to get transmitted. So as a user, you have no control over it. And to earn extra income, you don't know where all this data is being shared by the retailer, and the retailer is just one of the multiple examples where we go and leave a digital footprint. So I'm saying, in the absence of any safeguard, at least there is one step forward. Now, of course, there are challenges. Those challenges will have to get mitigated. There is going to be a cost implication. There are going to be contractual obligations, but companies will have to comply with that.
Okay. Okay. Kanishk, I want to quickly come to you. I mean, what would have been a better law? My colleague Karthik here suggesting that every time there is a law change, and which I think is true for all changes in law ever made, there is, of course, increased burden of compliance. There are contracts that you have to redraw. How would you then have, envisioned a bill like this where our footprints of common people, digital nagriks, as the government would like to call it, is also protected, is also, not abused, but at the same time, it makes it easy for companies to also comply with changes?
So my view is that we had split the Personal Data Protection Bill and the Digital India Act into two parts. If we were looking at creating a larger data protection regime within the country, we could have just have one single law getting passed and not split it into two. Because once this is done, there will be another version of the Digital India Act which is going to come in, right? So there will be significant amount of changes that the organizations will have to make again. So the cost of compliance is going to go further. So when you look at EU, they implemented GDPR at one go, whether it was for non.
All right. It looks like
bills multiple times.
Right.
Yeah.
Right.
Creating
Sorry,
precedents.
we can hear you again. Yes.
That increases the cost for everybody. Yeah. So that increases the cost so much. Even for government to do that again. Right now, we will move into the next session. The Digital India Act is not going to come in the monsoon session. That will move to December, the next session. So, right, another act coming in 6 months, how the industry is going to be ready for it. Significant changes around those, more costs. So a single law which comes out overall would have been a better choice. And that is happening. We've seen Pakistan, a country like Pakistan, come up with a data protection bill before India, and they have done it in one go. For a country like India, where there are, large data sets lying, doing it at one go would have been made much more better choice to look at, rather than splitting it into two parts, saying personal data looked at separately, the other part looked at done in another huddle. So that's primarily the aspect, and it will save time, consultations,
Right.
consent mechanisms. Yeah, I think that would have been a better way to make it.
Shweta, I believe from a product perspective, these are tech companies we are talking about mostly, right? Including one more page in the terms and conditions or one more pop-up that gives you allow your data to be shared or you deny your data to be shared would not be very expensive or very complex programming changes, I believe. At the other end of the spectrum, the offline services where your data goes, I think keeping a physical form or sending you an email that you reply with, these are easy, quick fixes that can be done. I'm not worried as much about the cost to organizations, to the data fiduciaries, as I'm worried about possible misuse of the powers of the government, right?
Yes.
Of the data protection board, not even the data protection board, but things that can come under the garb of national security. But then there are examples in the world. Look at Europe's GDPR regulations, among the most stringent when it comes to data protection. It is next to impossible for a fiduciary in Europe to share data without consent. There are these best practices available abroad. Look at what is happening with TikTok in the US. I mean, India banned it for a different reason, but there are Republican states in the US which want to ban TikTok because there is this fear that TikTok is transmitting data of US citizens back to China, which could be misused. Now, there could be a jury out there every time to discuss and debate whether this constitutes national interest or not, whether there is a vested interest or not. But I think as citizens, we should welcome at least some direction towards protection of our data. Of course, there are chances of breach. Of course, there are chances of misuse. Yes, there are chances of over-policing by the government and misuse by the government. Government, for example, using that data to run its own analytics to understand what content you watch on social media or which, I mean, eventually who you may vote for, who you vote for physically, the government may still not be able to understand using this bill.
But your preferences,
your taste, your preferences, your shopping habits, what you spend on, where you travel, which cities you've gone
all
to,
of that,
of course, can get accessed by somebody.
Literally
but at least by the government, not by just any other random company who happens to have your data.
I don't know which is bad, by the way.
Because one fiduciary had access to your original data.
I don't know which is bad. An entity having your data for political gains?
At least cut the risk by 50%. That was in any case available.
Right.
At least cut it by 50%, which is what I hope this bill will promise to do.
Yes.
All said and done, this has been a long time coming. It was withdrawn in 2021. There were 81 changes that were suggested and 12 additions by the Joint Parliamentary Committee. It's 2023 now. At least it has come. There will be fine print changes.
We don't know whether it will pass.
As far as we know, it hasn't been passed.
Right,
but
so it's been tabled
so
again.
It's been a long time coming. It's finally there.
All right, so it's been tabled again. We don't know if it's going to be passed again or not. We don't know whether the opposition is going to take it easy. We've heard a lot of opposition figures, including Manish Tiwari, talking about a need for discussion, debate on this. So Congress,
in fact, also
of course,
recommending that it should go back to the JPC before it comes back into
so
Parliament, and why it has been classified as a finance bill and then it becomes a money bill and escapes Rajya Sabha. But I think from what I understand, maybe it's tabling
now
in
it's
Parliament
being tabled as
right
a regular
now.
bill.
As a regular bill
So
should put a rest to
all the concerns. So it's not being tabled as the Aadhaar bill was tabled.
That's right.
It's going to be discussed, and all those discussions will be out in public forum. Kanishk, thanks very much for joining with your inputs. We will, of course, keep coming back to you. This is an important story. We want to know risks associated with data privacy, data protection. For all of that and more, we're going to come back to you. Thank you very much.